Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to get to talk about the state of Maine, but more importantly, we are talking about statutory waiting periods, which is not exclusive to the state of Maine. There are a lot of states that have struggled with this issue, and a huge ruling that has come out of that state that could spell the beginning of the end for really what is an amazingly ridiculous gun law, and one, of course, that has no historical tradition whatsoever. What are statutory waiting periods? Well, that's where you clear a background check and then the state decides, well, you're going to have to wait X number of days before we'll let you take possession of the firearm. And for what reason? Well, they can't really provide a good one. So today, let's geek out on the ruling and let's talk about a huge blow to waiting periods. Okay, hey, before we get going too far down the road we're going down, let's remember that this video is being brought to us by our good friends over at the Sonoran Desert Institute. That's right, get ready to launch your career in the firearm industry today. Get ready to start arming yourself with education today. And most importantly, get ready to start defending the inalienable rights of millions of Americans nationwide, all through our most powerful act, which of course is education. Listen, the Sonoran Desert Institute has a program, a certificate, or a degree for just about anything that you may desire. So for more information, check them out in the description box below, or easier yet, just visit them at sdi.edu. Okay, America and Maine, the case we're talking about today is the matter of Beckwith v. Fry. Fry being, of course, the Attorney General of the state of Maine. It is a preliminary ruling that comes out of the United States District Court for the District of Maine. Why do I mean a preliminary ruling? This is a ruling on an injunction. What law are we trying to enjoin here? Maine has a 72-hour waiting period, which means even though the next background check has come back and they've given you the thumbs up and yeah, they've got to proceed, you have to wait an additional 72 hours before you can actually take possession of that firearm. Now, that is actually a relatively gracious waiting period, because out here in the People's Republic of Washington, it is 7 days, which oftentimes turns out to be 9 or 10. I know California has lengthy waiting periods. I know Illinois has waiting periods, and I'm sure the list is growing by the day. So these statutory waiting periods is a big problem. It's a big problem because it's unconstitutional. The plaintiffs here made a very effective argument. And now remember, this is for an injunction. They're just trying to get the law paused while they argue the rest of the thing on the merits. And what do we need to show to get an injunction? Number one, we have to show that we are likely to succeed on the merits. And number two, absent an injunction, we're going to suffer irreparable harm. Well, clearly, the United States District Court in Maine has found that the plaintiffs have met both of those burdens. Now, you can imagine where the Attorney General of Maine was coming from, which is, hey, listen, the Second Amendment only protects the right to keep and bear arms. Doesn't say anything about acquiring them. As the court put it, Attorney General Fry argues that the act of purchasing or acquiring a firearm was not comprehended by the founders when they enshrined the right to keep and bear arms in the Bill of Rights. In his view, the Second Amendment only protects one's ability to keep and bear arms already possessed and does not provide an unfettered right to immediately acquire them free of any regulation. And obviously a very incredibly dangerous interpretation of the Second Amendment. One, by the way, if the courts in general were to ever adopt, would literally result in complete and utter civilian disarmament. As the court points out, though, it is an interpretation that is not only unsupported by the text of the Constitution, but one that makes the core right to keep and bear arms illusory if it is relegated to those arms in circulation at the time of the founding and through sales not subject to a background check. Now, on this whole issue about, hey, the Second Amendment only protects the right to keep and bear, it says nothing about acquiring or purchasing firearms. The court here did a really good job of going back through the Heller case and, by analogy, using Heller to justify the very common sense fact that, of course, the Second Amendment covers the ability to acquire a firearm, as the court put it. Here, however, we consider an enactment that temporarily bans keeping, bearing, and carrying activity that would otherwise occur but for its proscription. If a citizen cannot take possession of a firearm, then his or her right to possess a firearm or to carry it away is indeed curtailed, even if, as Fry claims, the curtailment is modest. However, the threshold inquiry is whether the Second Amendment covers the conduct curtailed by the act, not a qualitative assessment of how modest the imposition on that right happens to be. And that is the important impacts of Bruin right there, because the whole days of, yes, it does infringe, but ever so slightly, that is not part of the equation anymore. There is no interest balancing. There is no assessing of how grotesque the infringement truly is. An infringement is shockingly an infringement. And so based upon the fact that anything that delays you acquiring a firearm would, of course, then delay you from being able to keep or bear that firearm, the court comes to this conclusion. Because the act of acquiring a firearm, including by purchase, falls within the ambit of what it means to keep and bear arms, it is presumptively protected by the Second Amendment. Okay, which means the Second Amendment is in play, and now the state of Maine is going to have to justify this through some historical analogs. And of course, the problem, and we all know this is the problem when we're doing a video like this, is there ain't any, right? Now, the state of Maine, I think in a very smart move, tried to say, well, this is perhaps a more modern societal problem, not one that could ever be envisioned by the Founding Fathers. And therefore, we get to do that old little more nuanced approach. You know, you're going to get Rahimi'd on this thing. And all we really need to do is come up with something that is relevantly similar, right? Well, they tried that. And as the court put it, with this nuanced approach, the question is whether the act is consistent with the principles that underpin our regulatory tradition and or is relevantly similar to laws our tradition is understood to permit. And I actually like this approach by the court because it really does begin to limit that more nuanced approach. You're like, listen, I get we don't need to come up with a dead ringer, but the how and the why does need to be similar. Otherwise, the Founding Fathers would have never envisioned any sort of regulation of that nature when they ratified the Second Amendment. So knowing that, hey, this court appears to be entertaining that all you need to do is be somewhere kind of sort of close to the ballpark, what does Maine come up with as their historical analogs? Well, they come up with two things. That's right, background checks that we all have to go through, and then laws which prohibit individuals from possessing firearms while intoxicated. And as the court summarized it, Frey argues that the how and why of the act under review is aligned with delays associated with background checks and licensing in general, or perhaps with statutes that have long prohibited persons from publicly carrying firearms while intoxicated. But you see, one of the things that the court pointed out is that, hey, listen, there is at least some objective criteria to determine whether or not a person should be in possession of a firearm. With a background check, we are actually trying to establish their lawful ability to take possession of a firearm, and it is mandated by federal law. With intoxication, this is something that is subjectively applied to individuals who are in fact intoxicated. It doesn't just apply to everybody who occasionally may use alcohol, unless we're talking about the substance of cannabis, because then it does work that way, however, right? But as the court here in Maine pointed out, no one carries away a firearm before the passage of 72 hours from its purchase, regardless of individual circumstances. Such an indiscriminate waiting period law is not characteristic of our nation's regulatory tradition, as that tradition is reflected in background checks and prohibitions against drunken carry. And so maybe had the state of Maine's legislative scheme actually had some real standards by which we could assess that, hey, maybe some people need to wait an additional 72 hours, but maybe others don't. It appears that the court may have been willing to hang their hat on that, but that's not how this law, nor how any of these waiting period laws work anywhere in the nation. They all delay everybody for the same period of time, regardless of how many background checks you previously cleared. You're all stuck in this state of statutory purgatory, as the court put it. This act does not actually employ any standard at all, objective, narrow, definite, or otherwise. Whereas one might pass a background check or avoid prosecution for drunken carry by demonstrating a clean record or sobriety, respectively, law-abiding citizens cannot overcome Maine's 72-hour ban by measuring themselves against and affirmatively satisfying a standard. And the court, and what I think is the biggest zinger in the whole opinion, said, yeah, listen, about the only standard that is being objectively applied here at all is that you just have no faith in any Maine citizen whatsoever. That's just it. You just have no faith in the individual at all, as the court put it. In fact, the act is filled with and motivated by doubt. Doubt about what someone could conceivably do, but far more likely will not do upon carrying a firearm away from a cellar. And so ultimately where the court comes down on this waiting period law is, viewed dispassionately, the act employs no standard at all to justify disarming individuals, let alone a standard that can be described as narrow, objective, or definite. Consequently, I find that the plaintiffs have demonstrated that they are likely to succeed on the merits of their Second Amendment claim. Now, that gets us through one part of the two-part test, but we also have to show that we're suffering irreparable harm. And there is great debate among these circuits as about whether or not a violation of the Second Amendment right, standing on its own per se, constitutes irreparable harm. One of the reasons we wanted the Gray v. Jennings case to be accepted by the United States Supreme Court. The court here, in reasoning that, yes, it does constitute irreparable harm, has ruled, undoubtedly, deprivation of the right to keep and bear arms, particularly for purposes of self-defense, is of such qualitative importance to be considered irremediable through subsequent relief. Persons most harmed by the waiting period are likely to be seeking to carry for self-defense in case of confrontation. So the motion for the preliminary injunction has been granted. The case will proceed on the merits, but obviously this is very good news for the plaintiffs here because the court has found that they are likely to prevail on the merits. So it appears that this law is in significant trouble. Now, I bring this to everyone's attention because the reasoning employed by the court here is sound reasoning. And as we know, there are many other states around here, my state included, that have, in many instances, much longer statutory waiting periods. A right delayed is, in fact, a right denied. This court got it, and this may be the roadmap to start getting rid of some of these absolutely ludicrous laws in other states. Okay, the case, once again, is Beckwith v. Frey. We're going to link up the order of the court down below so that you can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, you just click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all that is down there in the description box. And then finally, and most importantly, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.